Pardon to make a mention, my lord. The mother of the petitioner died on 21st, my lord. And lordship,
Lordships, the sister's marriage, appellant sister's marriage was fixed to 28th. Your lordship had called for the report last week. কিন্তু এটা 28 କୁ ଅଛି ଆଜି ନହେଲେ କାଲି ଟିକେ take up
Kali ho. Lordship, verification of documents, lordship, petitioner jail cost since 5 years, lordship.
tied up with.
But the appellant has been convicted under section 7 and 13 of the PC Act, my lord. So for 6 months and
Pardon to make mention, my lord. One juvenile matter, my lord. In this case, one co-accused already released on bail matter. Yes, my lord. Obliged.
Please give it.
Pardon to mention, my lord. Highly interim bail, my lord. Last call for the report. Mother is seriously ill, my lord. Already report come, my lord.
Pardon to make a
Interim.
bail matter.
Give it.
Pardon to make a mention, madam. Serial number 7 2017 matter, madam. Earlier there is a listed, but it's not.
Bail matter.
No. It's a PC Act matter, madam.
For what purpose you are mentioning?
Hearing for hearing.
Huh?
Hearing for hearing, madam.
Hearing. Just wait. Next week you mention. Okay.
Next
All right. Yes.
Pardon to mention, my last option direct to obtain address verification. Address
Give
verification.
it.
Juvenile bail, my lord. Another tied up matter.
For
Bail.
That's a criminal appeal for bail.
My lord, judgment of conviction and sentence is under challenge, my lord.
Yeah.
I have prayed for bail and stay of realization of fine.
My lord, one bail adjourned to 16th of January, till now not listed.
bail matter.
Bail matter.
Give it.
One bail application, lordship call for address.
Pardon, lordship. CRL number 950 2023, lordship. 10 years sentence. Out of 10 years sentence, you have custody more than 8 years. Another for interim bail, lordship.
Item 10 kindly taken away. Item 10, my lord. Kindly taken away 1 week after. Today in the lower court date is fixed for trial.
Wait, why are you mentioning?
Weekly list item number 1.
May I please, your lordship? My lord, one actually assist this in under section 354 the IPC and under section 354A 509 34 IPC and 2
दे दीजिए मेरा 1 2 3 टा डिले कंडोन कर देबे बाकी एडमिट करी यूजुअल ऑर्डर कर देबे एडवोकेट एंगेज्ड वेटरे डिले नहीं आइटम नंबर सो इट इज टू बी एडमिटेड यस
Item 5.
Appellant was sentenced to undergo RI for 10 years and convicted under section 307 and sentenced to undergo RI for 10 years and to pay a fine of rupees 20,000 in default RI for 4 months.
Supply the deposition copy to the State Council.
In course.
All right. I for bail and sterilization of fine to be considered after receipt of the trial court. Yes.
Item 6.
Mr. Panda.
2-year conviction. PC Act on that.
Operative part.
Operating part, my lord, 69, paragraph 66 of the judgment.
2 years, 10,000, 6 months, 13 to so on. So then 1 year, 5,000 in default to undergo RI. You are on bail during
My
trial. So vigilance matter.
My lord, here in
Mr.
VC matter.
Das,
Yes, my lord, I have received the copy.
right.
I will file my appearance by the end of May, my lord.
Admit Mr. Sanjay Kumar Das, Learned Standing Counsel for the Vigilance Department, is present to virtual mode. He was on bail, so bail granted. Stay realization of fine. Will file the appearance memo by such and such date. Free copy of the order be handed over to the Learned Standing Counsel. Yes.
Obliged, my lord.
My lord, bail
Allowed.
obliged.
Item 8.
Mr. Ghade,
May I please, my lord, conviction is under section 376 2N. That is 10 years, my lord, and 20,000 fine.
My sentence under section under RI 10 years and 1 lakh rupees.
page.
Yes, 48, my lord.
10 years, 1 lakh in default to so and so. Okay. Admit. Supply the deposition copies.
Right now, I'm saying.
Huh?
Right now, I'm saying.
All right. Interim application for so and so will consider after receipt of the trial court. Yes.
Item 10.
And my kindly take no one after. Date fixed for
What is this matter? What is the CRLA?
The three-time matter. Last occasion, your lordship said 2 witnesses were to be examined. If your lordship sees the last 2 orders of the connected bail application, my lords, both the cases arise out of the same FIR, my lords. And now those 2 eyewitnesses have been examined.
Pashanti Naik and Rajeshwari Naik.
Yes. Rajeshwari Naik I had given on the last date, who is the informant and who has not supported the case of the prosecution. Now, my lord, so far as Basanti Naik is concerned, that copy also I have served today, my lords. And this is the copy for you.
File for the court. So
now all
out of now, how many witnesses have been examined? As on date?
9.
9, my lord.
So total 9 witnesses have been examined.
9.
My lord.
As per my lord's direction, my lord.
Yeah.
The eyewitnesses, namely Reboti Naik, Tamara Naik, Basanti Naik, Bhavani Naik, and Rajeshwar Naik to be examined first, my lord. Currently, all the witnesses, eyewitnesses.
What they have stated against the appellants?
My lord, as per the evidence, my lord.
Whose evidence you are?
My lord. My lord, kindly come to Tamara Naik, my lord.
PW?
PW 5, my lord.
She has supported the prosecution. Tamara Naik, bar karo. Tamara, TAM, okay. Yes.
My lord, then, my lord.
Then what is the name of the deceased? Tutu.
My lord, Tutu Naik. And the so far the Reboti Naik is concerned also, my lord. In your
this witness was examined as PW8 as well. PW8 Reboti Naik. The deposition kind.
My case.
Wait. PW8. Yes. No, that is not. PW8 kon lekhaichi.
Racist allegation that all the accusations are assaulted.
No. PW. This is special GR case, no? Number 9 of 2021.
My lord.
But it is something different. PW 9-8. PW 8 is not Reboti Naik. It is
My lords,
Rajeshwari Naik.
my lords, may I just clarify, my lords? In both the cases, since my case, my lords, I am for Gowda Pradhan, my case is being split up, and my case trial number is, my lord, special GR 9 of 2021 bracket A.
Okay.
So that is why witnesses are same, but their PW numbers are different.
Okay. Now,
So-
this, but
that
London Council for the State is referring to that
PW5 man.
PW5 in his case is Bhavani Naik, Mr.
my senior.
You please see his brief, Mr.
No.
His brief is the witnesses are different. The PW number is something different. So see that how Tamala Naik has been examined as PW.
No. Tamala Naik.
It's not Tamala Naik. Tamala Naik is too much.
June 23, August 23. So there's
It's a little different, but
No, Tamala Naik has not been examined in his case.
no.
As per my lord, directed to examine the common receipt and serve them. They went and deposed my lord.
Now they have no. The informant, my lord, has not at all supported. CS said that the deceased.
No, who has not supported, that is not relevant. Who has supported, that I have to see. So in your case, who has supported the prosecution case and what they have stated against you?
That's
then your case number is CRLA number 789 of 23, right? So the appellant's name is Gowda Pradhan.
My lords.
And he's in judicial custody since
23/4/2023.
3/4/23.
My lords.
Charge sheet submitted under section.
Under section 143, 364, 302, 34 of the 364.
Yes.
302.
Yes.
34 of the IPC.
Yeah.
Read with 3 clause 2 subclause B of the SC and ST. PA.
What is the date of occurrence?
Date of occurrence, my lords, 15/1/2021.
15/1/2021.
16/3/2021.
16/3/2021. My lords.
16/3/2021. 16/3/21.
My lords.
So in your case, as on date, you said 9 witnesses have been examined.
My lords.
And out of them, this Bashanti Naik has also supported the prosecution case.
My lords.
And what he has stated against you?
May I play, my lord?
Yeah.
I did on 2 o'clock, my lord. Because the deposition copy and the deposition both are different, my lord.
Okay, we'll take up tomorrow. Please
Well,
go through it. Eto khali London Council for the this is to be in CRL number 789 of 23. London Council for the appellant while the deposition copies of PW9 Bashanti Naik with a memo which is taken on record. He also supplied the deposition copy to the London Council for the State in court, who seeks some time to go through the same. Put up this matter on 27 February 2024. It will come tomorrow. Along with CRLA number 563 of 2022.
Item 11.
My lord, on behalf of Haraprasad Pandna, my lord, that matter is infructuous.
Infructuous. What is your good name?
Amarjit Wahi.
16. Have you got power in this case?
No, sir.
Please write your name in a memo and give it. So and so submits on behalf of. On whose behalf you are mentioning?
SP Panda.
Yes?
HP Panda, Haraprasad Panda.
Oh, mention on behalf of Mr. Haraprasad Panda that the CRLA has become infructuous. In view of such submission, CRLA is disposed of as infructuous. Yes, next.
Item 12.
Mr. Chan. CD available?
Allegation of firing is there.
Wait.
Again, my lord.
So,
we are appearing informant in this case.
Mr. Chand, is it the first application or earlier rejected?
First application, but allegation of my lord, allegation is there. So
Let us see.
without wasting my lord's time, may I pray? My lord, may I direct the trial to be expedited. If
Since
not,
when you are in custody?
I'm in custody. 18/7/2022, 18/7/2022.
So how many witnesses have been examined till date?
That my lord, the report was called for, my lord.
Okay. What is the total number of witnesses?
Total number of 23 and 24, maybe around 24, subject to correction. Last week. I have marked it with 24.
18/4/23 charge was framed. And 3 witnesses have been examined. Mr. Chand, how many total number of witnesses?
To my instruction, I have
34.
noted
34. Take down. Heard the learned counsel for the appellant, learned counsel for the state, and learned counsel for the informant. Mr. Chan, learned counsel for the appellant submit that the appellant is in judicial custody since 18/7/2022. And charge has been framed on 18/4/23. However, only 3 witnesses have been examined so far. He seeks for a direction of early disposal of the trial, to which learned counsel for the state as well as learned counsel for the informant has no objection. Review the status report submitted by the London Trial Court dated 13/2/2024, from which it appears that 3 witnesses have been examined so far. Considering the submission made by the London counsel for the respective parties, the period of detention of the petitioner in judicial custody, the number of witnesses examined so far, while not inclining to release the petitioner on bail, I direct the London Trial Court to expedite the trial and conclude the same within a period of 6 months from the date of receipt of this order. The petitioner is at liberty to renew the prayer for bail after, if the trial is not concluded within the said period. The London Trial Court shall do well to examine the material witnesses at the first instance. Copy of the order be communicated to the London Trial Court.
My presence for the informant kindly.
Mr. Dharanidhar Naik, learned senior advocate for the informant.
Item 13.
May I please? The case of 302, the bail in form of CRL.
Mr. Das,
Madam.
you have received the
Madam.
case diary?
Madam.
Okay.
Notice also served, madam.
Kebe?
2/11/2023.
Okay. Is it the first application?
Yes.
What is the date of custody?
Custody since month of June 2020.
Hmm.
June 2022.
13/6.
13/6?
13/6/2022.
22. What are the offenses under which charge sheet submitted?
Charge sheet submitted, Lordship.
302,
Yes.
34, 324, 307, 32B, 32BA.
What is the name of the deceased?
Raju Naik, Lordship.
Date of occurrence?
12/6/2022.
Eyewitnesses are there?
Lordship, 307 is there. Injury eyewitness is there.
Who are they? Tell one of the person who has received injury.
Anusaya Naik is the wife
of the deceased.
Anusaya Naik,
madam.
wife of deceased. Okay. What she has stated against the appellant?
May place, madam.
He just relevant post.
5 ଘଣ୍ଟା ସମୟରେ ପୂର୍ବ ସତ୍ୟକୁ କେନ୍ଦ୍ର କରି ଆମ ହରିଜନ ସାହିର ମନୁ ନାୟକ,
It is appellant.
madam, ପିତା ସୋୟଂଶ and ବସୁ ନାୟକ, ବସୁ ସ୍ୱାଇଁ ହାତରେ ଫାର୍ସା.
Oh, there are two appellants.
madam.
Okay. One ହେଲା ମନୁ, ଦୁଇ ହେଲା ବସୁ. ହଁ, ପଢନ୍ତୁ।
କାତି ଧରି ଆମ ଘର ପାଖକୁ ଆସି ଆମ ସ୍ୱାମୀ କାମରାଜୁ ନାୟକକୁ ନାନା ପ୍ରକାର ଅସଭ୍ୟ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲେ। ଏଣୁ ମୋ ସ୍ୱାମୀ ଆପତ୍ତି କରିବାରୁ ବସୁ ନାୟକ ଏବଂ ବସୁ ସ୍ୱାଇଁ ମନୁ ନାୟକ ମୋ ସ୍ୱାମୀଙ୍କୁ ଘର ବାରଣ୍ଡାରୁ ଝିକି ନେଇ ଡ୍ୟାସ ଭାଷାରେ ଗାଳି କରି ଆଜି ଜୀବନରେ ମାରି ଶେଷ କରିଦେବୁ କହି ଦୁଇ ଆସାମୀ ଧରିଥିବା ଫାର୍ସା କାତି ଦ୍ୱାରା ମୋ ସ୍ୱାମୀକୁ ହାଣିବାକୁ ଲାଗିଲେ। ଏହି ସମୟରେ ମୁଁ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ମୋ ସ୍ୱାମୀକୁ ରକ୍ଷା କଲା ବେଳେ ସମୟରେ ଆସାମୀ ମାନେ ମତେ ମୋର ଦୁଇ ହାତ ପାପୁଲିକୁ ହାଣିଦେଲେ, ଯାହାଫଳରେ ମୋ ସ୍ୱାମୀ ହାଣିଦେଲେ। ତାପରେ ଯାହାଫଳରେ ମୋ ସ୍ୱାମୀଙ୍କ ମୁଣ୍ଡ ବେକ ଦୁଇ ଡେଣାର ଗଭୀର ଆଘାତ ଲାଗି ରକ୍ତ ବୋହିଥିଲା। ମୋର ମଧ୍ୟ ଦୁଇ ହାତରୁ ଆଘାତ ହୋଇ ରକ୍ତ ବୋହିଥିଲା। ଏତିକି ବେଳେ ମୁଁ ମୋ ସ୍ୱାମୀଙ୍କୁ ପୋଲସରା ସରକାରୀ ଡାକ୍ତରଖାନା ଚିକିତ୍ସା ନିମନ୍ତେ ଆଣିଲି ଓ ମୋ ସ୍ୱାମୀଙ୍କ ଗୁରୁତର ଆଘାତ ହୋଇଥିବାରୁ ସେ ପୋଲସରା ଡାକ୍ତରଖାନାରେ ମୃତ୍ୟୁବରଣ କଲେ। ମୋ ସ୍ୱାମୀଙ୍କୁ ବସୁ ନାୟକ, ମନୁ ନାୟକ ମୋ ସାମ୍ନାରେ ହାଣିଦେଲେ ଓ ସେମାନେ ହାଣିବା ଯୋଗୁଁ ହିଁ ମୋ ସ୍ୱାମୀଙ୍କର ମୃତ୍ୟୁ ଘଟିଛି।
What is the PM report? Death was caused as a result of spinal cord injury, leading to spinal shock and complications thereof. So what do you say? There are eyewitnesses, let them be examined and then you renew your prayers. Heard the Learned Counsel for the appellant, Learned Counsel for the state. Learned Counsel for the state submitted that notice on the informant has been made sufficient since November 2022. 23. 2/11/2023. Non-appears for the informant. In view of the eyewitness account of Monosuya Naik, the widow of the deceased Raju Naik, and the post-mortem report findings, while not inclining to release the appellant on bail, liberty is granted to the appellant to renew the prayer for bail after examination of the eyewitnesses to the occurrence. Since the appellant is stated to be in judicial custody since 13/6/2022 and charge has already been framed as appears from the rejection order, the Learned Trial Court shall do well to expedite the trial and at the first instance take steps for examination of the eyewitnesses to the occurrence. If necessary, the summons be directed to be served to the inspector in charge of Buda police station. A copy of the order be communicated to the London trial court for compliance. Yes. Okay.
Item 14.
G.K. Goswami, S.N. Behera, S. Bari. You have received the
copy भी नहीं.
Huh? Okay. Oh, so many defects are there. पूरा defects ଥିଲେ କଣ list ହବନି ବୋଲି ହେଇଥିଲା
ଆଗରୁ ଏଟା ପୁରୁଣା ଏଟା.
Oh, acha. All right. Non appears for the appellant. It appears that there are number of defects pointed out by the stamp reporter. The London Counsel for the State also submits that he has not received the copy of the criminal appeal memo. Let the London Counsel for the appellant remove the defects as pointed out by the stamp reporter and also supply the copy of the appeal.
Item 15.
Yes,
Here,
Mr.
the
Cham.
bail has been converted to appeal matter because in
5D ଲେଖାହେଇଛି ମାନେ copy serve ହେଇନି.
I have filed the copy in say although it requires to be filed through appeal, I have filed it in I'll file a
You see that in that BLAPL the case diary might be available.
Well, let them solve a copy so that you can because
No, that you will do, but that CD may be available. What he
yes.
says that if it has been converted, give that BLAPL number. Is it mentioned?
No,
there?
it's 9757.
Okay. The London Counsel for the appellant shall supply the appeal memo to the Land Council for the state in court today. In court today. Since this bail up, the CRLA, the earlier the BLAPL application was filed, which was converted to CRLA, the London Council for the state seeks some time to verify the availability of the case diary in the said BLAPL. Put up this matter next week, Rakili, Mr. Tripathi. All right.
Item 16.
it will come. Yes, next.
Item 19.
Item 18, my lord, pass over, my lord.
No pass over. Yeah, Mr. You have received the case diary?
Yes, ma'am.
All right, it will come tomorrow.
Item 19.
May I please, the lords? And this is the case, your lordship.
What is the order dated 17/3?
Yes, that is all there.
In CRL number, कौन है?
462 of 2022, your lordship dispose of that matter. My lord, may kindly take page 3 of that order. Your lordship directed for expeditious trial and liberty was granted to the petitioner to redo his prayer in the event after examination of the eyewitnesses.
So what happened?
Eyewitnesses have been examined.
How many witnesses?
Totally 3, out of which PW2 and 3, they are the eyewitnesses.
So have you supplied the deposition copy?
Yes, your lordship. Last occasion.
So and for the court also, PW1 and 2 are the eyewitnesses.
No, 2 and 3.
2 and 3. But 3's evidence is not available.
No, last occasion I had.
PW3 of the evidence copy. Mr. Tripathi.
Yes.
Have you received the deposition copy of PW1, 2, 3?
Yes, ma'am.
Last page ko achi. ठीक है. So who has supported the prosecution case?
But it is by omniversal nature of allegation has been made that all the accused persons assaulted.
Yes, 2 and 3 have supported or not supported?
Supported to some extent.
Oh, कौन पढ़ुनाथी कौन?
I'm reading that.
About Mittu alias Murali Sahu, what they have stated.
Paragraph 5, your lordship.
Assault part is at paragraph 5.
Yes.
Okay.
Populenka, Robinaran Sahu, Sunil Ponda, Balu Samal, they also assaulted me by sword on my legs. Balu chased Mukesh Mandal to manage to free from the spot. Mittu called the threat. Mittu called the
this petition.
threat saying Mittu is the petitioner.
It's a case under section 302.
Yes, madam.
So what is your custody date?
Date custody is 5/4/2021, madam.
5/4/2021.
Total charge sheeted witnesses are 58.
Just a minute. Charge sheet submitted under section?
Charge sheet submitted under section 302.
Yes.
3 of the SC/ST Act and
Mr. Tripathi.
Yes, madam.
302 aur kichi IPC offense nahi?
Yes. 341, 427, 294.
Good, go slowly.
302.
Yes.
307. 34. 341. 427. 294. 326. 32B of SC/ST Act.
Okay, what is the name of the deceased?
Koraseti.
And there are injured persons also.
Yes, this PW1 is the
PW2.
1 is also.
1 and 2 are injured.
1
all right.
2. Sorry, my lord. PW2.
PW2 is the injured. Okay.
Yes.
So let us see that evidence which he was placing.
Yes.
So Mittu called threat. Please go on.
Mittu called
4 miller.
Para
4 ru arambha.
Okay.
Thereafter, we returned back to Jhadankuli and again went back to the feast at Palasigaon, and I came back about 6:30 p.m. My wife called and informed me that my father had not returned back home. I, along with Mukesh Mandal, went to Jhadankuli to search my father. Mittu Sahu, along with his brother-in-law Deepak Sahu, Kalia Sahu, came to the spot. Deepak Sahu, Kalia Sahu, lordship granted them bail. Mittu Sahu assaulted me on my head by means of sword. Kalia Sahu assaulted me by an iron rod on my left hand.
Just a minute.
He shows the
Mittu Sahu assaulted me.
Yes.
On my head by means of sword. Okay.
Kalia Sahu assaulted me by an iron rod on my left hand. He shows the scars injuries on head and left hand sustained by him, by me in the open court.
Okay.
Populenka alias Ajit, Robinaran Sahu alias Leth,
Sunil Panda alias Chillo Babu, Bhalu Samal, they also assaulted me by sword on my legs. Bhalu chased Mukesh Mandal to manage to flee from the spot. Me too called threat saying the slang. E dhoba satansat hairana koruchi. They all assaulted me by kick blows and damaged my bike. My father, on receipt of information, reached the spot and intervened to pacify. They all, in prosecution of common object.
That his father is the deceased.
Yes, Your Lordship. They all, in prosecution of common object, assaulted my father by sword, iron rod, etc. My father fell down unconscious in bleeding injuries. All my family members reached the spot. They took us to hospital by swift desire car on of my uncle. My father succumbed to his treatment. I was referred to Visakhapatnam for higher treatment as my condition is serious. I was examined by the police in this case. Well, here as I read out that so far the assault on the deceased is concerned and the presence of the deceased at the spot is concerned. Admittedly, there was some dispute between the PW2 along with the present petitioner and other co-accused persons. There was a free fight. Even the petitioner also sustained
What are the injuries sustained by the deceased?
Yes,
and also by this PW2. What is there in the PM report? This
is PM report, external injury in respect of the deceased.
Wait. So, as it appears, 6 external injuries are there. Lacerated wound, contusion, scot injury, then amputation of left little finger. All the injuries are antemortem homicidal in nature, so and so corresponding internal injury, hard blunt, so instead. External injury, so and so corresponding is sufficient to cause death. So one, Mr. Tripathi, as it appears that on the head there is an injury.
Yes, sir.
And that injury and its corresponding internal injuries are responsible, right, the causing the craniocerebral injury, that coma occurred, and that was the sufficient in ordinary course of nature. So, and that particular injury can be caused by hard and blunt force impact. So anything is there that what sort of weapon the appellant was holding?
Sword.
Sword. And anything that on which part he assaulted? That is not there.
Yes, that is not. And your lordship have granted a bail in Annex 3 series. I have enclosed the orders. Other co-accused persons.
Who has been granted bail?
Your lordship, that Deepak Sahu.
Where is the bail order?
Annex 3 series, my lord. So it starts from page 20. Page 20 is the order in respect of Ajit Lenka alias Popu. And page 26, that is Robin Naran Sahu alias Leth. Page 30 is the Kalia Sahu. And page 34 is Deepak Sahu. Only the petitioner is remained, all the other co-accused persons.
So, Mr. Tripathi,
Yes,
any distinctive feature so far as the appellant is concerned from the other persons who have been granted bail by this court? Because the eyewitness, who is the son of the deceased,
yes, injured.
He has stated that all of them assaulted by different weapon. This man was holding a sword. And that injury which is responsible for cause of death has been caused by hard and blunt weapon. So any criminal antecedent against it?
Yes.
How many cases? So what type of cases are there?
Your Lordship, my affidavit, Your Lordship, kindly refer. I have mentioned the case numbers.
Yes.
Paragraph 4, I have stated that Parampur Sadar PS case number 24 of 2014, that is under section 25(1)(b) of Arms Act, along with 192 MB Act, which is now pending before he is on bail, my lord. And another case, my lord, Parampur Sadar PS case number 152 of 17, corresponding to GR case number such and such, on offense 341, 452, 427, 294, 506.
So you are having 4 criminal antecedents.
No. Yes, so far the paragraph 7 I have mentioned, in course of the, your lordship granted interim bail. During interim bail, one FIR was also lodged. That I
So
committed.
that means you are misutilizing your.
No. That part, IO investigated and submitted final report, mistake of fact.
Which one?
That during interim bail, the allegation which was made. Your lordship, paragraph 7, your lordship may kindly read. See the.
Where have you stated that?
Paragraph 10, man. Page 3. The superintendent of police immediately directed one DSP to investigate into the case of the offense involved. In this case, related to such and such, the DSP conducted and vivid inquiry and investigation. Similarly, SP Barampur directed additional SP Ramesh Shetty to supervise the investigation, conduct DSP, and final report was submitted against my husband as false one.
No, that is so far as item number 7 is concerned.
Yes, my lord. And that is the allegation made that during interim bail I was committed.
And number 6, you have mentioned that ended in an acquittal.
Yes.
You have received the copy of this comprehensive affidavit.
Yes, ma'am.
So now let us say leave those 2. Still then number 4 and number 5 are pending against you. One is of the year 2014, the other is of the year 2017.
Yes.
Of course, these are magistrate tribal offenses.
Yes, sir.
So how many witnesses are left behind, eyewitnesses to be examined?
Eyewitness ke
Wait. You mean to say that PW2 is the only eyewitness?
3 also. 3.
PW2 and 3. And what about PW3? What he has stated? What is the evidence of it?
Similar allegation.
PW3 টা দিয়েছেন নাকি? Yeah. Oh, এটা আচ্ছা. I along with so and so. Has he stated
Paragraph
anything
3.
specific against this appellant?
No, may I read?
Mittu. Which paragraph?
Paragraph 3.
Okay.
Mittu hauled a threat saying that slang language. All of them got together being armed with weapons, assaulted Koraseti mercilessly. He was badly injured and taken to MKCG Medical Hospital in Marutikara, Littu Sethi.
And what is that line, Mr. Tripathi?
Yes, ma'am.
That he was armed with a sword? Who has stated that?
That is PW2.
PW2.
Yes. At para.
Okay. In paragraph 4, he has stated.
Yes.
Heard the learned counsel for the
PW3 also stated that
upper and learned counsel for the state. Who is appearing for the informant? Mr. Pramod Kumar Swai. None appears for the informant. Learned counsel for the. How many appellants are there?
Only one, man. Mittu, sir.
Appellant Mittu alias Murali Sahu submitted that the appellant is in judicial custody since 5/4/21.
Yes, sir.
And he has been charge sheeted under section 302, 307, 341, 427, 294, 326, of the Indian Penal Code, Section 3(2)(b) of the SC and ST Act, POA Act. He submits that the occurrence in question took place on
7/3/2021.
And Prashant Kumar Sethi, the son of the deceased Kura Sethi, and
Mukesh Mandal.
and Mukesh Mandal are the two eyewitnesses to the occurrence, and they have already been examined in the trial court as PW2 and PW3. And they have stated in an omnibus manner against the participation of the appellant in the alleged crime. Learned counsel submitted that as per the evidence of PW2 and PW3, the appellant was holding a sword. However, the postmortem report indicates that out of 6 external injury, the main injury is external injury number 2, which is a split lacerated wound over right variotemporal area. And it has caused fracture of underlying bone, which according to the doctor is sufficient to cause death. And such injury is possible by hard and blunt force impact. And as per the postmortem report, only external injury number 4, which is a superficial cut injury over the dorsal aspect of interphalangeal joints, can be caused by sharp cutting weapon. Learned counsel for the appellant submits that in view of such report, it prima facie appears that the blow given by the appellant, if any, has not resulted in the death of the deceased. He further submits that some of the co-accused persons have already been granted bail by this court in different CRLA, which he has annexed to this application as Annexure 3 series. The Land Council further submits that since the 2 eyewitnesses to the occurrence have already been examined, at this stage there is no chance of tampering with the evidence. He further pointed out from the comprehensive affidavit filed on behalf of the appellant that out of 4 cases instituted against the petitioner, comma, in one case, the appellant final report has been submitted. In the other case, the appellant has been acquitted, and the rest two cases are triable by magistrate. It is argued that in view of the period of detention of the petitioner appellant in judicial custody, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of PW2 and PW3, so also the post-mortem report. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, the post-mortem report finding, the release of the co-accused persons on bail, and the period of detention of the appellant in judicial custody, I am inclined to release the appellant on bail allowed. No. Yeah, appear before the learned trial court on each date when the case would be posted for trial. Yes. Gratefully asked.
Item 20.
164 statement will also be required. 376 along with 3 assist.
All right. The Learned Council for the state submitted that notice has already been sent to the concerned police station for its service on the informant, but the confirmation letter is awaited, and he has also not received the case diary. So also the instruction about the criminal antecedent, if any, against the appellant, and the matter may be taken up next week. As prayed for, list this matter.
Good week chhadi roke.
In the week commencing a week after list this matter in the week commencing from 11th of March 2024.
Lordship.
So and so we obtained in the meantime. CDCA confirmation letter.
164 Lordship.
So CD along with the 164. Yes.
Item 22.
My lords, offences are under SC/XT Act 3(2) of FIA, right?
What is the delay?
Delay, my lord, 70 days, my lord.
72 days.
70.
So notice has to be issued. Notice has been issued.
No, first time it has
First time.
You serve an extra copy of the CRLA, so also the interim application.
My lords.
IA number. So and so this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 72 days in filing the CRLA. Let the Learned Council for the appellant serve a copy of the CRLA memo. So also the IA on the Learned Council for the state by tomorrow.
By tomorrow, my lords.
By tomorrow, which will be sent by usual order per debe. So CD, CA, and confirmation letter to be obtained. Yes, next.
My lords, I pray one thing, my lords. My name to be reflected.
What is your name?
A Panda.
Huh?
A Panda.
Full name?
Ankan Panda.
Do you write in? Give him sleep. Yeah.
Item 23. Item 24.
This case is ready for hearing. In the meantime,
Out of 10 years conviction, the petitioner has already undergone 8 years, 7 months.
What is the offense here?
20B NDPS Act. Lordship, I have got the custodial certificate.
So you have never been released on
No.
interim bail?
No. Interim bail last occasion, your Lordship granted 3 months, but that benefit was not availed by the petitioner.
Then what can be done?
That benefit could not avail.
So now, why are you then pressing for bail?
No,
Bail has been granted. You are not able to furnish the bail bonds as per the terms and conditions. So don't insist for release on bail. And moreover, that order still subsists now. As and when you require, you are ready with the bail bond, you can, and the sureties, you can approach the trial court to get the release. So why once again the bail order? That was not that from a particular, it is applicable from the date of release.
My lord.
So that order still subsists. Appeal that order.
Your Lordship also directed to list this case for final hearing and for preparation of the paper book.
No, I'm asking you that why have you filed another bail application when you have already been granted?
Since the petitioner could not avail the benefit of
ପୁଣି
that
ବର୍ତ୍ତମାନ ମୁଁ ସେଇ ଅର୍ଡରଟା ପାସ୍ କରିବି ଆଉ 3 ମାସ ଦେବି କଣ ଲାଭଟା କଣ ହବ ଆପଣଙ୍କୁ ତ ବେଲ୍ ଅର୍ଡରଟା ହଁ ଚାଲି ଯାଇଥାନ୍ତା ଗୋଟେ ଥାନ୍ତା ଏଇ ପର୍ଟିକୁଲାର ପିରିୟଡ ଭିତରେ ଆପଣ ଯଦି ବେଲ୍ ବଣ୍ଡ ଫାଇଲ କରିବେ ତାହେଲେ ଆପଣ ଯାଇପାରିବେ ସେମିତି ତ କିଛି ନାହିଁ from the date of release ଅଛି ତାହେଲେ ଅସୁବିଧା କଣ ହେଲା?
Actually, in the meantime, almost all 9 years he is in custody.
ଚାହୁଁଛନ୍ତି ମତେ କୁହନ୍ତୁ ହିୟରିଂ ଚାହୁଁଛନ୍ତି ତ?
I prayed for final bail.
That you say you can, it will be listed.
Well, I have got the custody certificate. People Lordship.
No, don't produce it. I'm placing the place for hearing. Lekhondo. The IA number so and so, there is an application for bail. As it appears that the petitioner was granted interim bail for a period of 3 months from the date of release.
That is in IA number 651 of 2020 by the order dated 3/4/2023.
In IA number 651 of 2020 as per order dated 3/4/2023. The learned counsel for the petitioner appellant submits that the petitioner couldn't avail the said interim bail orders. The petitioner can right now avail such bail order dated 3/4/2023 as the interim bail period is applicable from the date of release. Therefore, I am not inclined to entertain this interim application for bail. Accordingly, IA is disposed of. CRLA number 70 of 2017. Considering the submission made by the learned counsel for the appellant that out of 10 years of substantive sentence imposed by the learned trial court, the petitioner has already undergone more than 8 years of
8 years, 7 months, 22 days.
8 years and 7 months of sentence. List this matter for hearing in the week commencing from 11th March 2024.
Obliged.
Item 25.
May I please, my lord? But I have filed my 2 miss case, my lord.
Just a minute.
Yes, my lord.
Yes.
But I have filed it two miss case, that is I number 2265/23 and I number 32 of 24, my lord. So I number 22/6 then we will not placed, my lord. That is filed.
IA number 2265 of 23. This is an application for early hearing. Mr. Rautral and counsel appearing for the appellant doesn't want to praise this interim application. Disposed of as not placed. Yes.
That IA number 32 of 24, my lord, I filed for bail. My lord, petition was granted, my lord, the interim bail for period of 4 months, and my lord, in subsequent 1 month, my lord, his custody since, my lord, 7/4/16. More than,
What
my
is the
lord,
sentence imposed?
10 years, my lord.
So what sentence you have undergone?
And undergone, my lord, 7 years, 6 months, 24, 7 years, 5 months, 24 days, my lord. Out of 10 years, my lord. And
So have you got that custody certificate with you?
that it was earlier called for, my lord, records, my lord.
What is that?
That is, my lord, on 11/7, my lord, 22, my lord. 2022, my
No,
lord.
22 तो अलग କଥା ବର୍ତ୍ତମାନ ତାପରେ ଆଉ କଣ ଇଏ ହିଁ
ତାପରେ
and what is your the conduct during the period of
Lord,
interim?
after, my lord, in the interval, has surrendered with the court will right time, my lord, I have given the, my lord, order that in miss case number 2265, my lord.
So Mr. Tripathi,
I'll
get
take it,
that
sir.
custody
Yes.
certificate, so also about report about his conduct while an interim bail from the concerned IAC.
Yes.
All right. The next IA number 32 of 24. It is submitted by the London Council for the appellant that out of 10 years of substantive sentence imposed by the London Trial Court, the petitioner has already undergone more than 7 years of
Yes,
sentence.
7 years, sir.
And he was granted interim bail
For 2 occasions, my lord.
on
For
2 occasions for a period of 5 months.
5 months, sir.
And after availing the same, he surrendered at right time. Let the London Council for the state produce the custody certificate from the concerned jail superintendent. Koodi achi kuhuntu?
That is, my lord, that is that Angul, my lord. It's Angul.
Who is stated to be lodged in Angul jail, and also instruction from the concerned IAC regarding the conduct of the appellant while on interim bail. Put up this matter in the week commencing from 11th March 2024. Yes, yes.
Item 28.
Yes. All right, non-obvious. The position copy you have received. Non-obvious 11/3/2024.
Item 30.
Yeah.
Yeah.
Item 30, your lordship, prisoner person therefore engaging Mr. Kahara along with my
Sachindra Kahar.
So, along with my associate, he's my
Okay.
associate. Power we have filed.
Sachindra Kahar is your associate. Okay, you have filed the B now.
Yes, sir.
So it is an application for bail.
My lords. In this case, your lordship was pleased to reject the bail application of the appellant on merit on your lordship 2/9/2021.
Just a minute. 2/9/21 order Takada. Okay, it's a case of gang rape on a minor. However, I have observed that in view of the age of the victim at the time of occurrence, the manner in which the crime has been committed, the substantive sentence imposed by the learned trial court, so and so. अच्छा, half of the substantive sentence
है नहीं
है ही नहीं,
No,
है नहीं तो आप पुणी फाइल कर देलगे
तो 8 ବର୍ଷ 5 ମାସ ହେଇଛି as on date.
पेंडिंग था लेखन
Lordship, in this matter, Lordship granted 20 days interim bail on the.
now you are not filing any application for interim bail, you are
Yes,
filing
Lord.
for regular bail.
My lord.
So in view of the previous order,
Yes, Lord.
wherein I have rejected, since it's a case of gang rape on a minor girl, so and observe that if after undergoing half of the sentence the appeal is not taken up for hearing, then you can renew your prayer. That period has not come, you have again filed the application.
That is there, but
If
meantime,
any
Lordship.
interim application is filed, that's a different matter. Take that ground and file with appropriate documents. We'll see. Look on the IA number so and so. This is an application for bail on merit. It
Present
appears.
Lordship, I am not pressing the present IA.
Okay. The learned counsel for the appellant submit that he doesn't want to place this application and intends to file an interim application for interim bail on some medical grounds. Court of this matter immediately after such interim application is filed. IA is disposed of as not pressed.
Number 31.
31 is an extension of interim bail.
Wait, just a minute. खाली लिखी जो out है. Period the prisoner's petition at flag G for engagement of Sachindra Kohar, advocate. It appears that Mr. Sachindra Kohar has filed Vinama along with other advocates. The Vinama is accepted. The name of the earlier engaged counsel, Mr. Saroj Kumar Subudhi, shall not be reflected in the cause list. Ali Saroj Kumar Subudhi तो बाहर करो से item 30. No, come to the front face. Saroj Kumar Subudhi, S.N. Mishra, and A. Swine shall not be reflected in the cause list henceforth. Okay, come to the next one. Item number 31.
31 this interim application is filed for extension of the interim bail.
Yeah.
Petitioner was granted earlier interim bail by your lordship on
When he was granted interim bail?
8/11/2023
for a period of
till end of December
so
2023.
that's expired since long.
No. Thereafter, I filed another petition, that is IA number 3061 2023.
Yes.
In that application, the interim bail was extended for period of further 2 months, which is due to expire on 29th, day after tomorrow.
Surrender.
Here the present your lordship annexed
surrender. Then we'll see. IA number so and so.
Because the health condition of the mother-in-law.
Interim bail. In view of the grounds taken in the interim application, I don't find any to extend the interim bail period. Accordingly, the IA stands rejected. The petitioner, learned counsel for the appellant, shall produce the surrender certificate. Court of this matter in the week commencing from 11th March 2024. Yes.
Here the health condition, because of the
File
health
yes, surrender and file another will consider. Yes.
Alarming condition.
Yes, next.
Item 32.
It will be 12.
No, it will be in that
Yes,
week.
11 I have already.
You want
Yes, I
a
have seen
specific date on 12th.
12.
All right, keep it on 12th. All right.
I have also handed over a copy of the order dated 29/11/2023. While granting bail to the co-accused, my lord has specifically that there is no material under section 376D.
We'll consider on that. Is it 376(3) there is conviction?
Yes.
So notice sufficient.
No, my lord, notice.
Is there any order, Mr. Pradhan, for issuance of notice on the since one of the offense under which the appellant has been found guilty by the London trial court is under section 376. Would 376(3) could नहीं था?
D 376D.
No, D रे notice दरकार नहीं छोड़ा. Yes, next.
Item 33.
Last of it, lots be directed to produce the custody certificate by the state council.
33.
33. Sorry.
Item number 33.
My lords. My last occasion lordship directed to serve the note of our
What is that for? What is the conviction here?
10 years NDPS.
NDPS. So how many period you are in custody?
I was in custody 11/9/2020.
So 10 years means you have not undergone 5 years of sentence. So now how do you overcome that bar under section 37? Supply him the written note of argument.
Yes,
All right. Or go through it, will take up. Learn counsel for the appellant files the written note of argument and also supply the same to the learned counsel for the state who seeks some time to go through the same. Put up this matter in the week commencing from 11th March 2024.
Item 34.
May I please, your lords. When it convicted under section 20B2C NDPS Act, my lord, sentence man arrive on a period of 10 years, my lord. Last occasion, lordship directed to the state council produce the custody certificate.
Yes, what
My lord.
period? କେତେ दिन ଅଛି?
1634 days.
ହରନ୍ତୁ ଆଜ୍ଞା. That 1000 ମାନେ ଏଇଟା ତ ହବନି 5 ବର୍ଷ ହବନି କେବେ. So you have not undergone half of the sentence.
Yes, my lord.
अरे ଯାହା ଦେଖୁଛନ୍ତି ମୁଁ
4 year 5 months 24 days. My lord. 4 year 5 months.
My lord, sentence part, my lord. 7/1/2000 judgment part, my lord. Page 13, my lord.
Please verify it. Your everything has been taken into account. Now the period is 1634, and what he has stated that it would be 4 years some months. 365 रे हरले 5 होउनी 365 गुणन 5 हेले 5 पंचा 25 5 2 530 2 32 2 3 5 3 15 3 18 1825 होउची एनी आपण को हिसाब रे कैलकुलेशन करले
Lordship, last occasion, lordship directed the interim bail earlier petition filed, my lord. 31/2023, my lord. Lordship,
have you received a copy?
No, my lord.
You please supply him a copy. A copy नेगिन देखो तो अपन calculation करो तो we'll take up this matter. Like learn counsel for the state produce the custody certificate and supply a copy of the same to the learn counsel for the appellant in court. Put up this matter as prayed for. Put up this matter in the week commencing from 11th March 2024. এটা রকি দিন তো না
Item 35.
May I please, lordship.
Yes.
Lordship, here I
surrender certificate.
Item 36.
No, please, your lordship. I it dispose of good. Huh? Your lordship was kind enough to on the last occasion 9-2. Your lordship was kind enough to call for the surrender certificate. I mean the custody certificate from the state council. The accused is unable. Is it available with you, Mr. Miss? Last two occasion.
And this matter will be taken up day after tomorrow. I have already talked to
Okay, day after tomorrow. As prayed for by the Learned Council for the state. Maybe 29. Okay. 29. মানে 29 ଆସିବ ବୋଲି କହୁଛନ୍ତି. Okay. Put up this matter on 29 to 2024.
ପଠାଇ ଦେଇଛି। ନାଇଁ ପା, ମୁଁ ପଠାଇ ଦେଇଛି, ପଠେଇଦେବି।
Item 37. Item 38.
May I please, my lord, through virtual mode? My lord, I am seeking for an adjournment as the petitioner has filed a writ petition the same matter before the Honorable Apex Court, and the matter is listed for today itself, my lord. I am seeking for adjournment for tomorrow, my lord.
No, it will be listed next week. It cannot come tomorrow. A mention is made on behalf of Ms. Kiran Pandey for adjournment put up this matter in the week commencing from 4th March 2024.
Please, my lord.
Kiran Pandey through virtual mode. Yes.
Item 39.
May I please, Your Lordship? The
Yes.
Item 42.
Mr. Mahapati, you.
At the outset, I will say that I cannot urge upon before this honorable court to release him on bail. But I am, for some other purpose, this is a case which was NDPS case detected by the excise personals.
Yeah.
And admittedly, the vehicle in which the petitioner was driving, it contains contraband article and it is huge quantity. But my concern is, your lordship, evidence that was annexed. Your
What
lordship
period you have remained in custody?
Yeah?
What period for the appellant has remained in custody?
Custody 5/3/21.
So that period is not at
Not just my concern, your lordship may consider it. I have gone through the evidence of the seizing officer. PW4, my lord. Cross-examination, your lordship have a glance. Is a very important witness so far this case is concerned.
No, do one thing. You file a written note of submission.
Yes.
Give a copy. Just indicate that you have already supplied the deposition copy. So let him go through it. If we find that you have a case, you can file your paper book so that it can be taken up early hearing.
On that point, I am also accepting, but I am concerned how the justice will be delivered if such type of cross-examination will be.
We'll consider.
Absolutely, there is no cross-examination. What sort of argument I will place before Lord? Only one sentence is the cross-examination. It is not a fact. It is not a fact. That is the cross-examination.
What can be done?
That is whole problem.
That is how this type of the trend is such that we are all worried about this type of the.
Exactly. I am also concerned that if such type of cross-examination will be carried on.
Cannot at the appellate stage when there is no cross-examination. How can you improve the case?
Exactly.
So
this is a very sorry state of affairs so far this case is concerned. As your lordship,
this is not being conducted by any state defense counsel.
No.
So
private counsel. Had it been in the conductor, I could have urged before my lord that substantive justice had not been done to the appellant. ମୁଁ ସେ କଥା ମଧ୍ୟ କହିପାରିବିନି ପ୍ରାଇଭେଟ କାଉନସିଲ ଏନଗେଜ ହେଇଛନ୍ତି କଣ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କରିଛନ୍ତି କେସ୍ କଣ
ଗୋଟେ ଲାଇନ ପଚାରି ଦେଲେ ବାକି ସରିଗଲା
ଆଉ ସବୁ ଯାକ ଇଟ୍ ଇଜ ନଟ୍ ଏ ଫ୍ୟାକ୍ଟରେ ଚାଲିଲା ଆଉ କଣ ଲସି ମେ adjourn it to some other day. I will examine
in such, because if it would have been a case of jail criminal appeal, we could have remitted the matter because of this.
Exactly.
But here is a private counsel.
Representative.
That order we cannot pass.
Exactly.
Now, whatever we'll see that if any non-compliance is there on the
only
case
that
officer,
is the
that
point.
otherwise,
If any mandatory provision was not complied with, that is the only.
All right, Mr. Saurachandra Mahapatil and senior advocate appearing for the appellant 6 for an adjournment. Put up this matter. We commence in केबे रखिबी कोंदो
कोटा शब्द छाड़ रखिलो
11 तारीख रखि दउची 11th of March 2024. All right, yes.
Item 43.
May I please, your lords?
Item 45.
May I please your lordship? My lord, in this case, my lord, the appellant has been convicted. Appellant has been convicted under section 20B IIC of the NDPS Act, and the amount of seized ganja, my lord, 22 kg, and by the time of alleged incident, the appellant was only 20 years of old, and after his arrest, he was represented by a state defense counsel.
So it is 10 years, 1 lakh fine.
My lord.
So how many years you have already
My
under?
lord, I am in custody since 9th April 2022. बेसी दिन 9/4/22.
What do you want? You have not undergone the half of the sentence.
My lord, shall I submit some latches of the prosecution?
That you are to file a written note of submission, supply him deposition copy of
Deposition I have already supplied.
So how do you overcome bar when there is a conviction against you?
There is
supply him the written note of submission. The learned counsel for the appellant seeks some time to prepare a written note of submission regarding the illegalities committed by the learned trial court in convicting the appellant under section 20B2C of the NDPS Act. Let a copy of such a written note be served on the learned counsel for the state. Kebe rakhibi kuhନ୍ତୁ? 11th. All right, put up this matter on 11/3/2024.
Oblige, man.
Item 46.
46. It is
on behalf of Mr. Rai Mallet, I am appearing.
Yes.
Mallet, here is the present appellant filed an interim application for interim bail.
Yeah.
1871. Your lordship, last occasion, your lordship directed
the IA number has been given as 2871 of 23.
Mallet, 2871.
कौन पूछें?
Interim bail, my lord. Your lordship direct the state government to take instruction.
On what ground you are seeking for interim bail?
My lord, the appellant is suffering from different cardiac disease and after complaint para 2 of the miscase, my lord.
Okay, Mr. Tripathi, have you received the instruction?
Well,
What has come?
so far the first item is concerned. So the data item ଅଛି.
She was placed the 1283 of 23. Binod Kumar Nath.
Binod Kumar Nath, my lord. I am.
The third page, your lordship. Doctor opinion is there, man.
एवढा कोण खाली मेडिसिन आउ से जो ECG report एठी एगुडा काइले कोण हबो?
The opinion is in the third page, your lordship. Third page, yes. Clinically, patient do not have any cardiac problem.
Patient previously consulted at so-and-so, diagnosed as acid peptic disease, so-and-so with so-and-so. Now, देखौचंदी तम. The clinically patient don't have any cardiac problem ଲେଖା ହଉଛି. ଦେଖିଛନ୍ତି report. Cardiac problem ଆପଣଙ୍କର କିଛି ନାହିଁ.
Report again.
BP normal ଅଛି 120/70 ଅଛି. कौन आपनकर असुविधा कौन होची? ECG report normal जଣା पड़ची, scanning पूरा perfect होची.
The appellant complain chest pain. Thereafter
chest pain को विभिन्न कारण पई हबो. आपन जो cardiac पई धरचंदी कोन पई? आपन तो ट्रीटमेंट हैला जଣା पड़ला cardiac problem नाही बेली. ECG हैला. आप chest pain ही गले तो बहुत कारण पई होथु chest pain केम हुए नहीं. So you are not making out any ground for this interim bail. If you can place the merit,
my lord, on some other day, your lordship.
All right, IA number 2871 of 23. This is an application for interim bail. Land Council for the state has produced the health condition report of the petitioner from Superintendent Sub-Jail Aska After going through the same, I am not inclined to grant interim bail. Stands rejected. IN number so and so. This is application for bail and counsel for the appellant 6 for an adjournment. Put up this matter on such and such date, with CRLA number 1346 of 2023. Eitaku IN number 2869 taku stay achi, stay realization of fine kar diyantu.
My lords, in the second appeal, my lords, I have removed the defect. A stay realization application is pending. Lordship may
All
kindly.
right, grant him stay realization of fine. Defect number 9 you have removed.
Yes, my lords.
Okay, Mr. Behral and counsel appearing for the appellant. Second item.
I'm obliged.
Submit that he has already removed the defect number 9 as per SR. Registry shall verify and report. Baki IN number so and so. This is an application for bail. तो ये ताकू जो date रखियो आपको सही date रखियो, है ना? Yes, नियम return.
I'm obliged.
Item 46,
46 को लाभरा. The third appeal.
47,
May I please, your lords? My lord, 20 years conviction.
IN number so and so. This is an application for bail.
Next week, madam. Next week.
It will come on 11th, not next week.
Item 48.
Yes, Mr. Devasis Mitra. Not there. Okay, non-appears, adjourn.
Item 49.
49, yes. Mr. Mishra.
Item 50.
Yes,
Please,
Mr.
I'm
Panda.
appearing virtually.
So last occasion, OPAD council was to submit with regards to condonation of delay application, their objections.
How many days delay? 106.
Miller.
Or have you filed any
In
objection?
course of the I'll file.
In course of
Yes.
All right, Mr. Patral and counsel special counsel appearing for the state of Orissa in OPID Act matter. It will like the IN number so and so. This is an application for condonation of delay. Submit that we will file the objection to the delay condonation application during course of the day. Put of this matter. Let a copy of the same be supplied to the Land and Council for the applicant. Matter be placed on 11th March 2024 for consideration of the interim application. Order.
Item 51.
51.
Item 54.
Lordship, kindly be pass on.
Not pass.
Lords, may I pray?
Taken up next week.
Can it be taken up tomorrow?
Mr. Pandey is there.
Can it be taken up tomorrow? I am there virtually, but I am suffering from it.
Why you want adjournment?
No, Mr.
I have
Das
a
is
sore
first case,
throat.
my lord, on behalf of Mr. Das, my lord. In the first case, Mr. Ponda is second case, my lord. And
No, it's all right. But
yes, my lord.
Any problem tomorrow if it is taken up?
No, tomorrow.
Or you,
My lord, taken up tomorrow, my lord.
okay, all right.
But I don't think Mr. Ponda's throat can be improved in the meeting. No, by tomorrow I think I'll be okay.
Because he is comfortable, I'll place it on his behalf.
ମାନେ ଆପଣଙ୍କର ଯଦି ଅସୁବିଧା
ନା
ଅଛି
ମୋର ଅସୁବିଧା ନାହିଁ।
ଆଉ କୋଉ ଭଲ ଡାକ୍ତର କହୁନାହାନ୍ତି କୋଉ ଆଚ୍ଛା କଥା
ଭଲ ଡାକ୍ତର
ସିଏ କହୁଛନ୍ତି ମୁଁ ଆର୍ଗୁମେଣ୍ଟ କରିବି ଆପଣ କହୁଛନ୍ତି ତାଙ୍କ ତଣ୍ଟି ଭଲ ନାହିଁ ଅଲରାଇଟ୍ ଟୁମରୋ ୟେସ୍
Item 55.
ୟେସ୍ ମିଷ୍ଟର ମହାନ୍ତି ଏଇଟା କଣ ପାଇଁ ଥିଲା stay of further proceeding there is already an order of stay
yes
we will vacate it nor what ଦେଖିଲ stay ଅଛି କି stay order pass ହେଇଛି এটা କାଇଁ ନାଇଁ ସେକେଣ୍ଡ ପେଜ ଟା କୁଆଡେ ଗଲା କି ଅର୍ଡରଟା ଇନକମ୍ପ୍ଲିଟ ଅଛି Is there any order of stay?
Because
nahi to
no.
All right, non-appears for the appellant, Mr. Vivekanand Bhuya. So also Mr. Jet Patra is present. The put of this matter adjourned for 11th of March 2020. Yes.
Item 56.
Limited 10 years for the offense under section 304 part 1.
ଦେଇଛନ୍ତି deposition copy ଦେଇଛନ୍ତି
ଏଇରେ admit it.
admit ହେଇନି କାଇଁ
ଏଇଟା
ଇଆଡେ
କଣ ଭକଲା ଆପଣ
Defect ଥିଲା defect remove.
wait ଆଉ କିଛି defect ନାହିଁ ତ
ନାହିଁ.
all right hard admit call for the trial court report you supply the deposition copies
Let's say we are appearing for informant. Let's say
All
we
right,
have already filed Voklatnama already.
କେବେ ଫାଇଲ କଲେ
So we have filed on 7th February.
କାହା ନାଁରେ ଅଛି ବି ନାମ
Akash Bhuya,
it is stated that Mr. Akash Bhuya and his associates
Lordship.
have already entered appearance for the informant by filing Bhinama. Let the registry place the Bhinama on record. The name of the learned counsel for the informant be reflected in the cause list. Let the deposition copies be supplied. Put up the interim applications after receipt of the trial court report. Admit informant. Yes.
Item 57.
One IA is there. It has not come to record, my lord. IA number 373 of 2024, wherein I filed application for bail, my lord.
Bail. Okay. Mr. Chang, learned counsel, appearing for the appellant, submits that he has filed an
IA number 373.
interim applications for bail, which has been registered as IA number
373, my lord.
373 of
2024.
with IA 373 of 2024. Put up this matter next week or with that 373. This you have supplied the requisition copy.
Right. I have filed.
59.
Interim applications to be considered after receipt of the trial.
Item 59 is connected to item 55, which has been adjourned to 11th. 11th না?
11 তারিখ রয়েছে
সেটা 12 তারিখ କରିଦେବେ। 11 ତାରିଖ I have some difficulties.
সেটা କହିବାକୁ ପଡିବ। ଆଚ୍ଛା ଏଇଟାକୁ କାଉନସିଲ ଆଚ୍ଛା ସେଟା ନନ୍ ଆପିୟସ୍ ଟା କାଟି ଦିଅନ୍ତୁ। କାଟି ଦେଇକି ସେଟା 12 ତାରିଖ କରିଦିଅନ୍ତୁ। କୋଉଟା ଯୋଉ ଆଇଟମ ନମ୍ବର 55 ଟାକୁ ଆଉ ଏଇଟା ଆସିବ ଆ ସାଙ୍ଗରେ ୱିଥ୍ ଆଇଟମ ନମ୍ବର 59 ହେଲା। ତ এইটার ବି କରିଦେବେ with 55. Yes, next.
Item 60.
Yes, Mr. Das.
60. Yes, Lordship. If takes page 16, the Lordships on the earlier date pointed out that here it's a judgment by the extent session judge, my lord. Judgment of acquittal. So an appeal against acquittal that I have preferred. Hence probably is to go before the sessions judge, my lord.
Okay, that is the right because only
additional hithle ithi tha.
Obviously.
Bhul hai rasa moro.
So maybe that limitation will arise, but you take that ground under section 14 of the Limitation Act that it was a wrong filing. That can be. I'm observing.
Lordship.
Mr. Abhishek Das, Land Council, submits that this CRLA has been filed under section so and so. It's like past paragraph. In view of the proviso to section 372 CRPC, the appeal is to be preferred before the learned session judge, and therefore he seeks permission to withdraw this CRLA in order to approach the correct forum. The certified copy of the impugned judgment be handed over to the learned counsel for the appellant on being substituted by the Xerox copy. In case the CRLA application is filed before the concerned court and with an application for condonation of delay, the land court shall take into account the provision under section 14 of the Limitation Act to condone the delay. Accordingly, the CRLA is disposed of.
Grateful.
So, no pass over matter.